Hello, welcome back to our YouTube channel. Today, I figured I'd kick off our conversation on what you need to do when you're on a hunt for a lawyer. So you understand that you might have some legal issues, or that you want to speak to a lawyer about your options, or you received a letter or documents in the mail from a law firm's office and you're totally stressed out and extremely emotional and are seeking the assistance of a lawyer to help you understand what is going on. You start frantically Google searching, and Google gives you your search results. You start calling lawyers, but you have no clue what to look for. Or you want to ask, or even what is even involved in the whole entire process. Some lawyers and law firms do 15-minute consultations. Those 15-minute consultations are usually free, and they do it to determine whether they have the necessary legal skills to take on your legal matter. You might ask what I mean by that. In Canada, there are solicitors and there are barristers. As you will often notice, barristers are often called litigators. So when someone says you need a litigator, that means you need a barrister. All lawyers can practice in both, but not all lawyers do. Some lawyers will strictly focus on solicitor work, which involves the drafting of legal documents, for example, drafting wills, shareholder agreements, legal policies, and they will also do some transactional work, which involves paperwork related to buying and selling a home, or stuff related to buying, selling businesses, and so forth. Solicitors will often never appear in court. Then you have barristers. Barristers are lawyers who go to court. They often go to court when dealing with conflicts. For example, you have a failed residential property transaction or a failed business relationship that involves you being oppressed as a shareholder. You are bringing a will challenge, you have issues with a bank, someone you share property with, or another professional body, for example, an accountant or an engineering firm, and so on. Criminal lawyers are also barristers. Just a little FYI if you haven't gotten the drift. So when you start looking for a lawyer, you have to determine whether you need a lawyer who has to negotiate on your behalf and put together documents for you, or a lawyer who has to go to court and advocate for you in the courtroom as well as outside of the courtroom by trying to negotiate for you a resolution that is in your best interest and benefits you. As part of the free consultation that some law firms usually do, or lawyers, for about 15 minutes, it usually occurs when you do your first point of contact with the law firm you're trying to reach out to. The person on the other line, or the person who's answering your call, if you have explained your legal issue in the email, would ask you what your legal issue is to determine whether the law firm you reached out to practices in that area of law or not. It's necessary that they do this because you don't want to go into a law firm or retain a lawyer that doesn't practice in that area and drives up costs trying to figure out what they're doing for you. During the initial free 15-minute consultation, if it's determined that the law firm or the lawyer does not have the necessary skills or expertise in dealing with your matter, the best thing they can do for you is direct you to someone they may know that has those expertise or their skills to help you. That's the best thing they can do for you. Once you grow through that 15-minute free consultation, some of law firms and lawyers like to call the screening process. It may be determined that a lawyer can speak to you about the litigation process relating to your potential legal issue by way of a free consultation. But the lawyer will not be able to give you any substantive legal advice or direction. It will not be able to look at your material. Because you have to understand that some of these legal issues, they could be very complex. There could be a number of parties involved. There could be issues you haven't noticed. So the lawyer has to really look at your material, really speak to you, gather the necessary important information to be able to guide you the right direction. If the lawyer or law firm does, during initial consultation, without looking at documents, for example, a contract that you have an issue with, or you might be saying was breached, if the lawyer gives you advice on that without looking at the contract, I would say that it's a big red flag unless the lawyer has looked at your material and has had the contract, or not even that, unless they dealt with the similar type of circumstances. Because if a lawyer tells you you do have a case with a breach of contract, that might be the first step. But if the lawyer cannot look at the contract and actually analyze the contract or determine what happened in that relationship, if there was any other paperwork, to do their own investigation by asking the right questions, if they tell you that you do, I would consider that a red flag to look out for. So do not be under the impression that if you call a law firm and they are there to speak to you, that you're expected to get that advice right away. Okay? It is important that you understand that legal principles might be the same across the board with regards to your legal issue, but the law is always evolving, and really strong lawyers rely on case law to either advance their client's case or to provide a detailed legal opinion as to the avenues their clients can take based on the evolution of the case law. I have a lot of colleagues in the profession who are senior lawyers. They were called before I was even born. And when they write legal opinions for their clients, they still do their research. And they work on separating their clients' facts from those used in the cases they already have been before the courts and have been determined by judges alone or by juries. When you do go to speak to a lawyer within the 15-minute free consultation, it is a way for you to get yourself to determine whether you want to proceed with retaining the law firm or lawyer to handle your matter, or you want to know that the person or the firm that you're considering working with is confident to handle your matter. Once you get past the 15-minute free consultation, you might feel confident enough to either proceed with a full paid consultation or retaining the law firm or lawyer to handle your legal matter. If you decide to do a paid consultation with the law firm or the lawyer, you will be told how much the law firm or lawyer charges. You need to ask questions like, does a law firm or lawyer charge by the hour? Is there a block fee? What am I to expect during this paid consultation? And so forth. If you're speaking directly to the lawyer who runs the law firm, the lawyer should be able to offer you the ability to either choose between a senior lawyer or a junior lawyer when deciding whether or not you're going to proceed with a paid consultation, a limited scope retainer, or a full retainer. It's always appropriate and often recommended that you do a paid consultation. The paid consultation will allow you to see if the law firm or lawyer is a good fit for you, and will also allow the law firm and the lawyer to determine whether you're a good fit for them. It is important to understand that you will have a close working professional relationship and a confidential working professional relationship with the law firm and the lawyer. And this relationship will potentially last for a very, very long time, and you need to determine whether you can work with each other. So you had the paid consultation, you had the free consultation, or you decide to hire the law firm or the lawyer because the lawyer understands you, is confident in taking on your matter, regardless of how complex the issues are. If you did not have a paid consultation and went to hire the law firm or lawyer on a limited scope basis, that means paying a retainer, which is like a deposit that sits in a trust account, and signing a limited scope retainer. A retainer is like a contract that outlines what the lawyer is and is not retained to do, among other things. Some law firms will have block fees associated with limited scope retainers and full retainers, meaning you've hired the law firm or lawyer to do everything on your file from start to finish. That means researching, investigating, writing letters, writing claims, writing applications, writing factums, doing motions, doing trials, doing discoveries, etc., etc. Block fees are rare in civil litigation, and they are often offered in criminal law matters, and basic block fees are often offered in simple solicitor work. They are also often offered to do specific things. For example, you want a lawyer to review your documents and write a detailed legal letter on your behalf. You will be asked questions like, how many documents do you intend on sending to the office, and so forth. The law firm or lawyer might determine based on that information they gather that that it is a matter that they can charge a block fee for. Be very careful with lawyers who tell you off the bat it will cost you $2,500 or $5,000. I would consider that a red flag, and so forth. If they have not had the opportunity to assess your case, the reason being is that you need to retain a law firm and a lawyer who is transparent about their fees. The last thing you want is the law firm or the lawyer to tell you that your fees are going to be, and then they actually charge you something totally different, which can be more than what they said, right? So some lawyers will say it's going to cost you this much. If there's money left over, they would return it in their trust fund. Some lawyers will say that it's going to cost you that much, but then it's triple the cost. So it's always important to understand that getting a fee assessment is the way to go. The last thing you want is any surprises in terms of the fees that you are being charged. Majority of those people who do practice in litigation charge by the hour. You should be given the information as to how much the lawyer charges by the hour, along with how much it costs to have their law work on your file, and so forth. This is usually included in the firm's retainer. If it's not, it should be attached as an appendix and communicated to you. Sometimes you might want to know the cost of the entire litigation process, although it is very important to know whether you can and cannot afford litigation. It is absolutely expensive. I can tell you it's very expensive, and I'm telling you that now so you understand. It is hard to determine how much it would cost overall. The cost of litigation really all depends on what avenue is taken. There are costs for initial stages, i.e. drafting, communicating with the parties, investigating, and so forth. There are costs associated with negotiating, doing discoveries, which is called dispositions in the U.S., to examinations, costs associated with motions and court appearances, costs associated with arbitration and mediations, and costs associated with trials, filing costs, service costs, all kinds of costs. It is very important that you retain a firm or a lawyer that will sit with you before you reach each stage in the litigation process to work with you on determining the cost of that specific stage. It also goes down to number of dates, number of parties, material, and so forth. A good lawyer will sit with you and tell you how much each stage is going to cost you for you to prepare for your litigation. Further, it also depends on whether you are representing a corporation or not. Corporations tend to have budgets dedicated to litigation. The law firm will have to stay within that budget that is determined prior to the law firm being retained to act on behalf of the corporation. I hope today my video gave you some information, some very, very important information on what you need to look for when looking for a litigation lawyer in Ontario or in Canada. Even anywhere, you can ask these questions to any of the lawyer or law firm you intend on hiring. I'd like to make it very clear that I am not providing any sort of legal advice. All of this is just information. If you would like to speak to me or a member of my staff, please reach out to us at 416-606-5405 or email us at office@melaw.ca and hit the subscribe button. We look forward to sharing more videos and more information with you.